And Miss Daniels, listen. God damn it, I know what I said might not sit well because I talked about the offspring you had with that thing. I know you can make a better looking baby than that. I'm willing to show you, goddammit. I will take vitamins to make sure I shoot to the spot where the cute baby at in the back of you.
This show is not suitable for all audiences. Listener discretion is advised.
We ain't done. Y'all know what the fuck it is, man. Let's go. Oh my God, I'm not even at my best yet. I can't slow down, it's a death threat. She said, oh, it's really cause of me. I'm like, yes.
Gotcha, bitch.
Diamonds in the cut, I ain't need a medic. Like a brown skin, big booty, yeah. And her name and legacy said, I'm not your girl. Don't call me a legacy, sorry, you right. That's my bad. That shit get tricky when you running out them bands and the crew really like me. I'm the man. I'm like, girl, I'm in the zone. I'm like, girl, leave me alone. We done made it all.
Within a month, I done knocked down about 5 of the just praising God.
You just gotta wait for them to tell their testimony. That's how you know how to get them. You used to be hooked on what? Oh, okay, I know.
What's the girl name again? Kiki or something? The broad who was with dude.
Oh, the chick.
Abe said it.
Man. Oh, Mika. I'm sorry. Mika, but I saw you talk. Mika. I know you know what's up. The way you left out of here and you wasn't saying nothing, I know you know what's up. Work the lane. You ain't got to stop with the lane. But what I'm saying to you is this. If you looking for a real lick in life, I'm talking about some knowledge on who to be for real. Not that fake. Come put in work with a real. Don't talk around it. And don't be shy about looking for this knowledge because I seen it in your eye. You want this knowledge. Come get it. I didn't look at you because I knew you was with the little lane. Get your hustle on the butterball. But what I'm saying that, and the reason I'm saying this, you can play this stuff in front of me and you. He to run up on him in front of you.
But what makes y'all think that got more street cred? Because they dress like this? Because they dress more hood? Because of shit that they do on stage? What makes real? What makes somebody real? Because they say that they real? Because they say they from somewhere? Or did they stay down in the city that they was allegedly born from and hold it down and continue to add value to it? I'm still in my same city that I was born and raised in. I can move anywhere I want to move in the world. All that, I'm from the streets, I represent it. Man, got it, shit, bro. Like I don't have the same respect.
No, you talking loud, and you still talking around. What did the Caucasian male do to America to bring it down?
I'm not getting into that.
You dancing around it. And that's why I lose respect for you when you start dancing and kissing Caucasian male.
Now, they don't add that part in there. Why don't they add that part in there?
And Miss Daniels, listen. God damn it, I know what I said might not sit well because I talked about the offspring you had with that thing. I know you can make a better looking baby than that. I'm willing to show you, goddammit. I will take vitamins to make sure I shoot to the spot where the cute baby at in the back of you. So, nigga?
As always, please like, share, and subscribe to the New Culture Empire for all things legal, court, finances, and sovereign citizens review. And do the same for Drama Newz, where if there's drama, it becomes the news.
You're rocking with the best. You're rocking with the best.
What is good? Y'all already know what it is. A special. The New Culture Empire and Drama Newz. This is a joint. Because after this, then it's going to be uploaded on Drama Newz. I am the pro se litigant, blueprint in these spaces.
So?
Although I am not a licensed attorney, I have over 22 years of experience dealing with court, criminal, and civil. I understand court rules, understand rules of civil procedure, and I understand the nuances of court.
That boy is good.
So?
And this is where we get to the legal side, because that's exactly what I cover on my channel. So the Rita Daniels and Leslie Daniels recent lawsuit against Corey Holcomb for 5150, I said, wow, what an opportunity to break that down. Many people, first of all, when you attack someone's kids, to me personally, I don't see the connection between Anton's daughter and his situation with Corey. I don't see the connection. You attack the wife. So it looks bad.
So?
But one of the things that makes this interesting is I find it odd that in these spaces, and y'all remind me of that lady's name. She makes like every day is a video about Anton and his wife and Mika, the light-skinned lady. I think she went to jail before. One of those. One thing that I didn't understand in these spaces is we always talking about protecting Black women and protecting our young Black sisters. We always talk about that. And I've always noticed to see women run to the defense, even lie for other women, even lie about the looks of their kids, just because they don't want to hurt their feelings. See, I've seen all that. But then I start to notice that I've always said the sisterhood is fake. The sisterhood is fake.
But I thought y'all supposed to have a sister. I thought they're supposed to have a sisterhood. Y'all supposed to be protecting Black women from everybody. Don't matter who it is.
And one of the things that I've noticed, and what's that guy Cellulite podcast? I was watching a little bit of that earlier. The Angry Man was on there. Shout out to the Angry Man. I think Diesel TV was on there earlier too. Shout out to them. But I noticed that he was scrolling through the comments when that lady was calling his Anton's daughter ugly.
Because I can tell you right now, this live chat, I want y'all to see who in this live chat. Let's pay attention to the live chat.
You got? Why don't you fix your ugly daughter? Your daughter is ugly, Anton. She's so.
Let's see. Let's go down here. Look who in there. Uppity. Uppity said, "Let's go." Oh, I'm about to call y'all out by name now. Mic drop. Look at mic drop. Who else is in here in attendance? Not calling this Black woman out for saying that this daughter is ugly. And who else is in this chat being messy?
Funny looking
Razzbo in here.
Telling me who I am. Go back over there and suck Anton little bitty. How about that?
It's all just show.
What's up in here?
You know what I mean? I don't know what you're saying. Shut your up. My Keisha, stop talking about people. You're past.
Uh-oh. Is that Bomb Cherry? Ooh. Is that Bomb Cherry? Oh my God. Not Miss Feminist. Oh Lord, not Bomb Cherry. Not Bomb Cherry.
His ugly daughter.
Wait.
Somebody put in the chat, why go after his minor daughter instead of his wife?
I'm the one that said in the chat, why go after his minor daughter and his wife? I got blocked for that comment, just so y'all know.
First of all, the young girl, she's not ugly. I mean, I don't know why you even saw it. There's nothing wrong with her. She's very talented. She went to the junior. Now she's very, seems like she's very smart, very educated, got her head on her shoulders. I don't know her age. I think she may be close to 18. I don't know. But you had a Black woman calling Anton's daughter ugly.
Is this all you got? Why don't you fix your ugly daughter. Your daughter is ugly, Anton. See, I was trying to give you the benefit of the doubt, but you took it.
And then you had people in the chat, black women. Cellulite said your name already, so I don't have to say it. Cellulite said your name. He said the name already. You know,
Is that bomb cherry?
I'm trying to figure out why is it that when you're on one panel, you're like, hey, protect black women, protect these young girls.
Oh, Reese Cup. See how that's rules for thee and not for me? See how that standard flip?
Oh.
You don't know Anton. You don't know Corey. You don't know me. And yet you're in my chat. You don't know Lakeisha, but you don't go to her chat.
It's from the ones that like to say, these men. See, these men. These men.
Is that bomb cherry?
But come to find out, ladies, y'all didn't protect a young black girl from a older black woman who was putting her down.
And people is in the chat agreeing. That part, facts.
Where's the protection at then? I thought, am I missing something? Where was the protection at? Where was all the people that had things to say about what men do to women and black men and black women? Where were they at when she made that comment about Anton's daughter, about her look?
If I said that, if Kevin would have said that, if any black man would have said what she just said, what do you think would what do you think the reaction would be, bro? Speak. What would be happening right now?
Live stream after live stream. Black men don't protect. Black men hate black women. They hate their mama. They hate their sister. They weak and all the one. The white men don't do this.
Because if it was your child, you wouldn't have liked it. But let me guess. I got a theory.
So, what's the scoop?
Nah, I think I figured it out. I believe that the hatred for Anton Daniels is so much that it doesn't even matter who does what, who attacks him, as long as it's doing something to affect him. Now, all this protect the black girls and protect our women, that goes out the window when they don't like you and that black woman just so happens to be associated with you. See, that's why I say the sisterhood is fake.
Exactly.
Let's fast forward from that. Now we have the lawsuit. Now, I know emotions are rolling. People are, hey, it's going down. California is going down. And the optics, it does look bad. But now you're stepping in a court of law. Now there's the emotions comes out of it. Now there's certain legal thresholds that has to be met in order for you to state a claim upon which relief can be granted. And we're about to break this actual lawsuit down. All right. Now, shout out to the homie Ali for pulling up this case for me. So, they're suing for defamation per se, false light. Now, the false light, their attorney, that was actually a good strategic move. Defamation of Leslie Daniels with respect to the t-shirt images. Defamation of Rita Daniels with respect to the t-shirt images. And infliction of emotional distress suffered by Leslie Daniels. Intentional infliction of emotional distress suffered by Rita Daniels. In violation of California Civil Code Section 3344. Number 5 and number 6 creates an issue for me. Number 5 and number 6 creates a legal issue for me because Corey Holcomb can say, I did this and to insult him. They were just collateral damage. Now, they have to prove that he intentionally meant to a emotional distress and harm and all the elements of psychological damage. Like, I'm going to do this to you on purpose, Sharita and Leslie. My personal take in that moment, I truly believe that he was actually doing it to take shots at Anton. And his attorney may be able to spin it. No, we did it, but we was taking shots at him. See, here's the thing. We get the looking at the actions, but we're not adding the legal lens to it. The legal procedure on the elements that has to be proven. So Corey can actually say, nah, yeah, I'm taking digs at him. I didn't wake up in the morning and say, I'm going to hurt you. I think they used them to hurt Anton. Not justifying what he did, but his lawyers could be like, we was taking digs at him.
I was stabbing at that.
So comes now, plaintiff Leslie Daniels and Rita Daniels and filed their complaint in this action for damages against Lamont Holcomb in the 5150 show as follows. Anton, I got a question. Who prepared this draft? Who put this together?
I don't know.
Okay, here we go. True names and capacities where individuals, corporate representative or otherwise of those 1 through 25 inclusive are unknown to plaintiff, who therefore sue them by fictitious names. Plaintiffs will seek leave to amend this complaint. What did I say? To show the true names and capacities of said defendants when they are ascertained. What did I say? I say it looks like they about to amend it. This look like it's just no court. Please share it, like it. I know you probably think I don't know what I'm talking about, but trust me, I specialize in taking down multi-billion-dollar corporations. Most recently, Credit Acceptance Corporation. Wherever it is alleged that any act or omission was also done or committed by any specifically named defendant or by defendants generally, plaintiffs hereby intend to allege and do allege that the same act or omission was done and committed by each and every defendant named as a doe and each named defendant, both separately and in concert or conspiracy with the named defendants. See, this is where it gets at me personally. I probably wouldn't, because now see, this is okay. So if you're saying one at all, now you got to prove that they met in a room, conspired to do this. You could just have people that's sitting on the stream that's just there, nodding their head. Now you have to show intent. I believe by trying to add everyone in Corey's actions, I believe you're kind of forcing yourself, like the bar. You're raising a bar for yourself. If you're suing his company, out of the 25 defendants, are you suing the company? You're suing everybody that was in the room that day? Are you suing his manager? I'm pretty sure if you try to sue his company or who he works for, he's managed by, they're gonna be like, we ain't know he was gonna do that. So the lawyers are gonna defend that. Are you gonna sue YouTube if the video is up and not taken down? Because that's allowing him to still profit from it. You see what I'm saying? These are a lot of questions. To be honest with you, this took place in January. In February, you filed the lawsuit. See, if Anton Daniels would have reached out to me, see, we'd have been going over all this. We've been going over all this. Now, I'm going to see, as we read this, I'm thinking, if the lawyer does what I'm thinking now, I'm not about to say it, but I'm thinking, if the lawyer's going to do what I think. Because in any civil lawsuit, one of the biggest, most important things that you always have to do is you always have to lay a foundation that ties into your legal cause of action. Supreme Elite Team, we went over my case last night. You see how that flowed like the Niagara Falls? So we're going to see. Now, plaintiffs are informed and believe, and thereon alleged that each defendant herein was an agent, employee, or representative of the remaining defendants. That's what I'm thinking they're getting at. They're probably suing this management company. They're suing the person who had the camera. They're suing whoever held the shirt up. They're suing people in this. I see where they're going. And each of them, and that each defendant was acting within the course, scope, and authority of that relationship, and negligently or intentionally in the matters hereinafter alleged, acting in concert with the other defendants and or was an aider and abettor with others as to the conduct. I knew they was going to go there. I knew that's where they're going with it. Being on the scene of a crime and even knowing a crime is about to be committed. It's like you're on the scene of a crime with me and you know what I'm about to do. You know, just because you know and just because you're there doesn't mean you intended to participate. See, now they have to prove the actual end, because Corey's lawyers can easily say, hey, they're sitting there, we're all having a conversation, and the conversation flowed that way. I'm just giving you objective. Like, these are like, when I look at lawsuits, I look at from all angles. I'm not saying this not about who's right, who's wrong. We already know. I truly believe Corey shouldn't have went that far with it. I don't think it was necessary. Talk about him, keep it on him, and move on. But all the extra stuff is kind of what's going to cause him to potentially have some liabilities in this case. But we got to see how it plays out. Plaintiffs are informed and believe, and they're on alleged that the Doe defendants are responsible for the acts alleged herein, and that they were acting as agents, employers, or representatives of the named defendant and within the scope of their agency in doing such acts. See, that I just feel like I feel like you're casting a wide net, and understandably so. But if you're going to cast this wide net, you have to know the who, what, when. How do you know they're acting in concert? Just agreeing with someone in the phase of a situation or a topic. Who printed the shirts? Who came with the idea to print the shirts? Like, it's a lot more that goes into it than that. Factual background. Upon information belief, on January of 2026, the Corey Holcomb 5150 show was aired through YouTube and had a wide audience in the United States. Yes, I was there. I watched it. It shocked me. The show was aired on or about January 13, 2026. Anton Daniels, the father of plaintiff Leslie Daniels, and the husband of plaintiff Rita Daniels, appeared on that show. After introductory comments were made by defendant Holcomb and the guests, the two individuals became involved in an intense, heated discussion, and provocative remarks were exchanged. I don't know if I would have, I don't know. The following week, January 20, 2026, defendant Corey Holcomb aired another 5150 show. During the show, the defendant twice aired a photograph of Leslie Daniels standing immediately in back of an American flag. Timestamps. The defendant Holcomb clearly identified plaintiff Leslie Daniels as the daughter of Anton Daniels. While the photo was shown, host Corey Holcomb made disparaging and highly offensive statements about plaintiff and her father. Defendant Holcomb referred to plaintiff Leslie Daniels on the broadcast as an ugly at 2:05:46 of the show. The defendant knew at the time that the statement was made that plaintiff was a minor. The statement was made intentionally to disparage and demean plaintiff. Now, this is where Corey Holcomb, right there, it looks bad for Corey. But this is the part where I start to believe where Corey's lawyer, they may come in and say, no, we were in a mutual combat war of words, and I did that against Anton, not so much against Leslie and Sharita. The defendant expected at the time that he would profit monetarily by ridiculing Leslie Daniels and subject her to scorn, since his podcast has promotions for products that bring in substantial income. Now, this is where the nuances of court comes in at. Right here, let's read the sentence again. The defendant expected at the time that he would profit monetarily by ridiculing Leslie Daniels and subjected her to scorn, since his podcast has promotions for products that bring in substantial income. Right there is an issue, because you just made a legal conclusions. And courts, judges, they hate when you make legal conclusions. On the next show, January 27, 2026, defendant Holcomb exhibited for his audience a t-shirt which depicted plaintiff Leslie Daniels as an 8 and depicted plaintiff Sharita Daniels as an 8. Now, there you go. See, I would have put the last paragraph, he expected to profit by ridiculing. I probably would have slid that in right here, because now I got an actual merchandise, and part of his stream is to make money off the merchandise of his stream. Yes, even in court, the positioning and the wording of the words. Now, this sentence right here, down at the bottom, 7, the defendant expected at the time that he would profit monetarily by ridiculing Daniels, subjecting her to scorn, since his podcast has promotions for products that bring a substantial income. I would have said right here on the next show, January 27, 2026, defendant Holcomb exhibited
for his audience a t-shirt which depicted plaintiff Leslie Daniels as an ape and depicted plaintiff Rita Daniels as an ape. Since Corey has a show and part of his substantial income comes from profits, one can conclude that the merchandise and the advertising of the shirt was going to bring a substantial profit. See how I would have tied. I know it seems like I'm going over the word, but it's called laying a foundation for court. Defendant Holcomb explained that viewers of his podcast could purchase the t-shirt. Well, there you go. Check mark. Ding. He alleged that all money received from viewers will be donated to the family of a woman shot in Detroit by ICE agents. Now, let's say that's the alleged, right? So now we're getting into charity. So is he really profiting from it, or he was donating the money? Because now we get into the gray areas and the nuances of court. Did he actually profit from it? Did he receive a benefit from this, or did he donate it? And this is where we would get evidence that he didn't do it. When it gets to trial, Ms. Sharita, your lawyer, that's what you subpoena. Documents showing that the money, subpoenaing the proceeds made off the shirt, the proceeds, all that may subpoena the records, the statements, and finding out if was any of that money donated to the charity like he said. Can Corey, his defense probably gonna be like, I ain't make no money off it. Like, this is just how courts go. See, there you go. To date, no account. I'm telling you, I be seeing, once I stop at agents, I'm getting in my zone. I didn't even read that part. To date, no accounting for the funds for the t-shirts has been rendered by defendant Holcomb. Upon information and belief, all proceeds from the t-shirts have remained with the defendant. That's why I said what I said when it gets to discovery. If it gets to that stage, yo, get the accounting, have your lawyer. I'm telling you, I know I do this in real life, not online. Everybody give an opinion about the case. I literally do this in real life. I literally have clients in real life. Now we get to the legal cause of action. Defamation per se. Ms. Daniels, I don't like this one because let's read it out. And then Corey Holcomb on his podcast of January 20, 2026, falsely stated that plaintiff Leslie Daniels this is a disparate. See, this is the part what I'm saying. Legal conclusions. Legal conclusions. And what Federal Rules of Civil Procedure, Rule 12b-6, and every state law's equivalent, stating a claim upon which relief can be granted. Threadbare recitations or legal conclusions is not really a good way to attack it, because this is a subjective point of view here. This is a disparaging and misogynistic slur for particularly one who is masculine or butch. I would have worded it, this word is used when discussing a boom, 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 and it's often used in communities to disparage or attack someone. You don't say this is disparaging. No, it matters in court. It matters yes, it matters. Normally, basically what I'm saying is, instead of saying this was disparaging, I would have said this term is damn sure ain't used as a term of endearment. You get what I'm saying? It's normally used in a negative light. And I would attach the culture around that word to him saying it. So anyone can infer, anyone can concur, the jury can be like, well, you damn sure ain't say it as a greeting. Defendant Corey Holcomb on his podcast of January 20, 2026. See, I wouldn't have said falsely. See, that would be in my relief for request. See, I would have summed it all up like that. After I'm done saying what they did, when I sum it all up, we get to the conclusion, then I will put that was false. I'm telling you, it's little things. I'm telling you, lawyers nitpick like this. Yes, I know professional lawyers. Spoken to people who sit in high places. They nitpick. Falsely stated that plaintiff Leslie Daniels was... Okay, we did that. Plaintiff Leslie Daniels is a heterosexual and is not... The false statement was made by defendants intentionally to demean plaintiff and subject her to ridicule. Who? Defendants knew the statement was false at the time it was made. On the alternative, defendants failed to use reasonable care, there you go, to determine either the truth of their falsity of the statement, yet made them anyway without regard to their truthfulness.
Oh, no, she didn't.
Cool. I like that alternative. Plaintiffs are entitled to recover compensatory damages. It's maintained that defendants knew the statements were false and acted with conscious disregard of a child's rights. The statements were made with oppression and malice in an effort to disparage plaintiff and damage her personal reputation, and to subject her to ridicule among her friends, classmates, and the viewing audience. As a result, plaintiff is entitled to recover punitive damage. All right, you're still doing it.
Emotional damage.
Never mind. False light, a very strategic move here. Defendant statements about plaintiff Leslie Daniels on the podcast of January 20th, 2026 show plaintiff in a false light. Defendants falsely stated that plaintiff was the false light created by defendants would be highly offensive to anyone in plaintiff's position. You're still making a legal conclusion.
Emotional damage.
It's not the elements, it's the wording of it. Anton Daniels, I'm going to take this and I'm going to email you my version of this lawsuit, what mine would look like. I want you to compare down to the discovery request, down to the subpoena request, and if you got to take a deposition, the questions that'll be asked in the deposition. That's a real life fact.
Historical, unbelievable, amazing.
At the time that the statements were made, plaintiff was vulnerable, unshielded high school student. Defendant knew the statements made would create a false impression about plaintiff. Defendants acted with reckless disregard of the truth. Plaintiff Leslie Daniels was harmed by the public statements made by defendants. The statements made by the defendants were a substantial factor in causing harm to the plaintiff. As a result of the foregoing, plaintiff requests compensatory damage and amount determined. Third cause of action, defamation of Leslie Daniels with respect to the t-shirt. And I believe, and from my litigation model, these are really her strongest parts. Not really the other stuff, like there, right here. Defendant Holcomb's exhibit of the t-shirt with the picture of plaintiff Leslie Daniels portrayed as a monkey, right here. I would have said this.
그렇게 하는 거 아니야. 미국은 좀 다르게 해야 돼.
Defendant Corey Holcomb exhibited a t-shirt with the picture of plaintiff Leslie Daniels portrayed as a monkey. Bam! It was demeaning and unmistakably racist image. It's still considered a legal conclusion. That you save all that stuff when you get to your end, when you're summing it up, just the facts, not how you felt about it.
Emotional.
At the time that the t-shirt appeared on the screen, defendant Holcomb made clear to his viewers that the figures appearing on the t-shirt were members of the Anton Daniels family. Perfect. The depiction of black people as apes or monkeys is a deep-rooted, racist, and dehumanizing trope with a long history designed to deny the humanity of African-descended people and justify slavery and discrimination. This image is understood to be so degrading and demeaning that it cannot possibly be passed off as satire or humor. I agree. There's not a term of endearment when you got a person with a picture of a monkey.
I don't think there's no way in hell.
The image of plaintiff Leslie Daniels as an ape was and is defamatory. Plaintiff asserts that the depiction of Leslie Daniels as an ape was meant to be a defamatory and derogatory act on behalf of the defendant. The plaintiff contends, plaintiff believes that defendant did not mean any good cause or any good faith in depicting plaintiff Leslie Daniels as an ape. You see how the difference in that wording matters? Plaintiff Leslie Daniels is entitled to recover compensatory damages. The image was displayed by defendant Holcomb with sneering condescension and with oppression and malice, and in an effort to disparage and dehumanize plaintiff and to subject plaintiff to ridicule. At 1 hour, 55-minute mark, plaintiff defendant Holcomb can be seen making sneering, condescending marks with oppression and malice. In the video, he said, blah, 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 while holding the t-shirt. See the difference? See, I get to the details. I would have shredded Holcomb with this lawsuit. I would have shredded him. Man, I would have put Leslie Daniels so much as the helpless, hopeless. My God, how could you do such a thing to these people? When I was done with it, see, I'd have been reviewing the video. my guy, Anton, if you was to hire me just to prepare the suit, you can get the lawyer to argue. You get just to draft it.
I just think enough is enough.
I would have, okay, what case law in California were people laws for the same conduct as Corey Holcomb? In this case, such and such this case, we have your back. Now, fourth cause of action. Defendant Holcomb's exhibit of the t-shirt with the picture of plaintiff Rita Daniels portrayed as a monkey was a demeaning and unmistakably racist image. At the time the t-shirt appeared on the screen, defendant Holcomb made clear to his viewers that the figures appearing on the t-shirt were members of the Anton Daniels family. Okay, see timestamp at this. Fifth cause of action, intentional infliction of emotional distress suffered by Leslie Daniels against all defendants. By publicly declaring plaintiff Leslie Daniels to be an ugly and by exhibiting and selling a t-shirt containing a picture of her as an ape, defendants called plaintiffs to suffer severe emotional distress. Okay, did you go see a therapist behind it? Did you have to go see a doctor? Because if you did, that would be good evidence. Did it stop you from your daily life? See, now, I'm not, it may look like, man, which side you want? It's legal, it's court. But emotional distress, you kind of, it's hard to prove emotional distress because somebody says something that you don't like. So I'm expecting the lawyers to be able to substantiate the emotional distress. Defendants knew that plaintiff Leslie Daniels would hear the false and degrading description of her and would know that Corey Holcomb and the 50/50 show were hawking a t-shirt with the image of her as an ape. Plaintiff did in fact hear the defamatory description of her seeing the degrading t-shirt with their image. Defendants knew that emotional distress would probably result from their conduct or gave little to no thought of the probable effects of their conduct. How do you know that emotional distress? See, that's what I'm saying. This is one thing. It's still called a legal conclusion. You're still making legal conclusion.
Gentlemen, we are live!
In a civil complaint, is it appropriate to make legal conclusions for the purpose of California's Rule 12b6 motion? In a California civil complaint, it is not appropriate to rely on legal conclusions to survive a demurrer, which is California's equivalent to a Rule 12b6 motion.
It's off to a splendid start.
Meaning dismissing a case for failure to state a claim upon which relief can be granted. Because California is a fact-pleading state, your complaint must allege ultimate facts rather than legal conclusions. Why legal conclusions are insufficient? No assumption of truth. Why a judge must assume all factual allegations in your complaints are true during the demurrer, they're not bound to accept legal conclusions as true. This is a legal conclusion. Defendants knew that emotional stress would probably result from it. There's no way he can know that. I'm telling you, there's been a lot of legal conclusions throughout this complaint. A defendant can demurrer if a plaintiff does not state facts sufficient to constitute a cause of action. If your complaint only recites the elements of a law without supporting facts, it will likely be sustained for legal insufficiency. Ultimate facts versus conclusion. You must plead the ultimate facts that support each element of your claim. The legal conclusion, the defendant was negligent or the defendant breached the contract. Ultimate fact, defendant drove 60 miles per hour in the 30 miles per hour zone, or the defendant failed to deliver goods by the day specified in the written agreement. That's an ultimate fact. He knew by doing this would be this. Defendant knew she would not feel good if he did. Those are legal conclusions, Sharita and Anton Daniels.
Emotional, damn it!
Distinctions to keep in mind. California is fact pleading and is stricter and requires specific details for each cause of action. Evidentiary facts. You do not need to include evidentiary facts, the specific evidence we'll use to prove your case, like William's name or exact documents, but you must include the ultimate facts that define the dispute. Now, let's go. Let me do this right quick. Right here. Watch this. From 51 on down, are there legal conclusions cited? There you go. Yes. Starting from paragraph 51, the draft relies heavily on legal conclusions rather than the ultimate facts required by California's fact pleading standard. I know what I'm talking about. I do this in real life. Trust me, I just spanked a multi-billion-dollar finance company.
You're rocking with the best.
He said, this shit ain't going nowhere. I know that's one of the big, but you want to know where it goes somewhere? No BS. If Anton Daniels watched this stream and reaches out to thomaslegacy603@gmail.com, right? And allow me to re-put the motion together for him, the complaint together, and his lawyer can still argue. Too many legal conclusions. I started when I seen it, I was like, you keep saying he knew it was this. No, California is actually stricter than federal courts. It's more lax than federal court. As a matter of fact, Anton, we would have filed a federal lawsuit. Right, we would have filed a federal lawsuit. So it says yes, and I screenshot that one. Starting from paragraph 51, the draft relies heavily on legal conclusions rather than the ultimate facts required by California's fact pleading standard. While some of these statements are common in complaints to frame the issues, they are legally insufficient on their own to survive a demurrer if they're not backed by specific factual allegations. That's why I was saying, if I would have wrote this complaint, I would have had the timestamp or where he said it, and then a quote, a little citation of what he actually said. Look at these monkeys on the screen or something like that. I would have had that, and then Exhibit C, timestamp. So now you can see he said the own words. See, that's a factual allegation. I said, yeah, he did this by doing this. Yeah, now I'm backing it up with his own words. I'm Rita, Anton Daniels. I'm telling you, I told you, everybody had their opinion online today, but I'm telling you, not many people online in these spaces. I'm telling you, I do this in real life. I've been stamped by professionals that many people would never even run across to in real life. Yeah, it's just
Jeff Gamble.
Mr. Gamble, how you doing, sir?
I'm doing well, thanks.
Yeah, hey, nice talking to you. I just wanted to let you know personally, I appreciate your help with the matter of resolving this with credit acceptance. I did receive the title. Appreciate the fast expedition on that, but just wanted to give you a thank you, man. I appreciate your hard work, man.
No, I'm glad we were able to work it out.
Yes,
and you were a big part of that process too. So
yes, most definitely.
Just sit for a bit, and the momentum when really people are working towards the goal.
Yep.
Really helps.
Yes, sir. Yes, sir.
I too am thankful for your role in that as well. But I really appreciate the cause.
Yes, sir. My Supreme Elite team members in here, they'll tell you. Paragraph 51. Defendants knew that emotional distress will probably result such and such. Status. Legal conclusion. Recklessness. Intent. This recites an element of the IIED. You must plead facts showing why they knew it would cause distress. They knew, e.g., they knew the plaintiff's personal history or sensitivity. Paragraph 52, at all times, defendants were reckless in their conduct. This is a pure legal conclusion. Stating someone was reckless is a determination for the judge or the jury to make based on the facts provided. That's why I said you don't. That's for the jury to make. That's for the judge to say. And I tell my Supreme Elite team member group this all the time. You don't say their conclusion, they did this. That's for the judge to decide. I literally preach this to my students all the time. Do not make legal conclusions. That's why when you see my lawsuits, they read defendant contends, defendant asserts, defendant believe. Like I never say, okay, they did this and they did this. I leave it open-ended for the judge to close the lid on them. Y'all did this. I know they did it, but it's not for me to say they did it. It's for the judge to say they did it. Now clip that. Paragraph 54. Defendant's conduct was gross and despicable and beyond the bounds of human decency. It's a pure legal conclusion. This is a restatement of the egregious conduct element. You must describe the specific actions that meet this high bar. And I said this at the beginning of the stream. Man, I was like, how they're wording it and stuff. It's like they're kind of forcing themselves in a higher standard in a bar to win. And I like Anton Daniels. I ain't got nothing against him. I think the real issue for a lot of people is that he's just a successful black man that many people don't like what he says. I think real reason is Anton Daniels' success kind of forces people to accept their lot in life, and some people their miserable existence that they call a life. This is why you may have that woman that makes a video about him every day. I'm trying to figure out why they ain't cut Anton Daniels a check. The biggest fucking sports broadcasters today. He was just on Stephen A. Smith. You wouldn't even bump into Stephen A. Smith. I mean, come on. Regardless of how he got his money, whether he made investments or y'all say trust fund, regardless, why does everybody have to just be struggle? We gotta struggle. It gotta be hard. We gotta struggle. What's wrong with people not struggling? It ain't so much about what he says out his mouth, because if you like him, you wouldn't care what he said. It's just he's a successful black man that most of y'all don't feel deserves it. And y'all wish you had his money. That's all it is. Y'all can say all this, he doing all this, all that. What you're really mad is he lives the life that y'all wish you could live. Anton has way more money than me. That ain't even no secret. But what the are you hating him for? He says a lot of things that I know people don't like. I say a lot of things that people don't like, and you probably say a lot of things that people don't like. But y'all spend so much time on this man, and it looks like he just continues to win. What they say he made like in January, $300,000? What he make like, what they say he make $150,000 on a low end a month on YouTube? What the, you're not stopping nothing. All those videos y'all making about him, y'all not stopping nothing. What I'm starting to think y'all doing, y'all just pimping y'all audience. I don't really think y'all that mad about him. Y'all know the audience really feels some type of way because in many of these chats, it's a bunch of low-hanging fruits. So y'all really pimping them as well, playing them on their own emotions. So they can send you super chats. So they can send you cash apps. So you can run off the bag on airtime. Y'all really don't have the beef that you think. You want to do some like shock value content about them so it could just put eyes on your channel so you can monetize it. Let's just be honest. Because if you're trying to shut him down, obviously it's not working. Obviously, he was just on Stephen A. Smith, and Stephen A. Smith reached out to him. Yo, I've been watching your stuff. All the people that's making content about Anton, you think Stephen A. Smith watching y'all? You think he watching y'all? What's going on, Crystal? How you doing? You think they're watching y'all? And you know what's so sickening? For y'all to hate someone so much that you will stamp and approve a man talking about his daughter, who's innocent in the situation, who has nothing to do in the situation. And y'all would just act like it didn't happen, or because you don't like Anton Daniels. Where's the morality at? Where's the protect our young black girls? Because y'all be so quick, we are protecting for these men, but next day, y'all hop y'all black up on the panel talking about how we need to protect our women from these men when y'all wasn't protecting another black woman from another woman talking about her. Y'all faking phony. This is why a lot of y'all in the same miserable existence that you call a life. There's nothing positive about y'all. Everything's just negative. They just walk around so mean and angry. All because a man on YouTube says things that you don't like. What? Look how low you have to be. A man on YouTube is saying things that you don't like. We ain't talking about your dad, your uncle, everybody that you're around every day. You're talking about a person on YouTube, to the point that y'all will keep running his watch hours up on a man that you don't like, but you'll continue to go over to Room 9 in the Millionaire Morning Show and run his engagement up just to say things to try to get under his skin. As soon as he go live, you don't like him so much, as soon as he go live, you'll leave the content creator that you like just to go to the channel of the men that you don't like just to troll. And you talk about just all men, we just devilish. Man, all y'all like the drama. All y'all like the BS. All y'all like it. It's Drama Newz. All y'all love drama. Because as soon as that man that you don't like fire up a live stream, y'all run y'all black over there and sit there for hours. When a man that they don't like fire up their stream, they'll leave right over there. Look at this shit. Yo, woo, wee. Good God almighty. All right, let's get back to this right here. So, defendant, lines 9 and 10. Defendants were guilty of malice and oppression. Pure legal conclusion. These are specific legal terms used to justify punitive damages under Civil Code 30 without specific facts showing a conscious disregard for your rights. This phrasing is conclusory. 56. Defendants cause plaintiffs to suffer severe emotional distress. Another legal conclusion. Causation and damages. Simply stating you suffered severe distress is a conclusion. You need ultimate facts describing the nature of the distress, nature, medical treatment, physical symptoms. Remember I just said emotional distress. What did I say? Did you go see a doctor? You're gonna see a therapist behind it. Did the therapist diagnose you saying it's based on this event that it happened? Like, I'm not wrong. I know what I'm talking about. At all times, defendants were racist in their conduct. Legal conclusion. To a court, racist is a characterization of behavior. You must plead specific racist acts or statements, e.g., the specific imagery on the t-shirts or words spoken that supports this characterization. So, pleading facts versus conclusions. Defendants were reckless, 52. Why does the conclusion? It labels the behavior without describing it. What the ultimate facts look like. Defendants released the image despite receiving a cease and desist letter on date. That's the example. Another one from the complaint. Conduct was beyond the bounds of decency. Why is it a legal conclusion? It cites the legal test for the IIED. What an ultimate fact looks like. Defendant sold a t-shirt depicting plaintiff as an ape to a live audience of people. See, that's how I would have worded it and left it right there. Because the judge could clear, like, hold on, that wasn't right. See, I'd have left it right there. I'd have left all out of this ended for the judge to just close the lid on, like I did in my own lawsuit. The title to my vehicle that I won in my lawsuit, part of my settlement of a multi-billion-dollar company. I think I know what the hell I'm talking about in civil lawsuits. Plaintiff suffered severe distress. Why is it a legal conclusion? It labels the harm without describing its impact. What a ultimate fact looks like. Plaintiff was unable to return to work for a number of weeks and sought treatment for panic attacks. That is what I'm talking about. Hey, Anton, a suggestion. Take her to a doctor or therapist or, seek a little treatment for your daughter too. Go seek therapy right quick. I would have told them this right around that time. Go seek therapy right quick. She can't go to school, had to pull her out of school. Things are going wrong. Hey, have her go seek therapy. Get that documentation. Because when we get to the emotional distress, we can prove it.
Emotional, damn it.
If they didn't already do that. I've been working with Anton. All right, Anton, listen, give me 2 weeks. I got to read this video. I got to watch the video again. I got to internalize it. I got to walk it. I'm probably watching. I'm about to take about 5,000 notes because everything he's saying something that's going to support the elements of my facts. I'm copying it down. I'm putting a timestamp. All right, blue check timestamps that is here because this is actually a real easy case because you can just convict him off his own words and his intent. And we lay the foundation where he, and then I would use all the facts and evidence that's leading up to him making a live about your wife and kids, and I would have laid the foundation where you reckless intent, you knew what you were. Oh my God, man, God Almighty! And let's just read 56. By exhibiting and selling a T-shirt of her as an ape, defendants caused plaintiff Rita Daniels to suffer severe emotional distress. Defendants knew, here we go again, that plaintiff would hear that Corey Holcomb in the 5150 show were hawking a t-shirt with the image of her as an ape. Plaintiff did in fact see the degrading t-shirt with her image. As a result of defendant's action, plaintiff had to seek mental treatment from a therapist. Plaintiff couldn't return to work. Plaintiff was in fear of leaving her home because she's known and he has a broad audience in fear of being ridiculed in public, which caused plaintiff to start having panic attacks and had to go seek treatment for it. Man, hold on, y'all. Defendants knew that emotional distress would probably result from their conduct or gave little or no thought to the probable effects of their conduct. No, don't. As a result of the foregoing, plaintiff is entitled to compensatory damages. Defendants' conduct was gross and despicable and beyond the bounds of human decency. Defendants were guilty of malice and oppression. As a result of the despicable racist trope, the plaintiff is entitled to an award of punitive damages. 7 cause of action. Violation of California Civil Code. Section 34. Defendants violated California Civil Code. So right there, instead of saying defendants violated California Civil Code, I would have started off by citing California Civil Code and citing the elements, what the statute says. Under California Civil Code says, this is what the code says. And then I would approve how their actions violated the code instead of saying they violated the code by displaying the photograph of plaintiff Leslie Daniels, a minor, without prior permission of plaintiff or of her parents on January 2026 for commercial profit or gain. That's a good wording there, but I would have said like, defendants knew that plaintiff was a minor, but still aired on the live stream. Instead of saying defendants acted with malice. You see that hits different? You see how it hits different? Defendants knew that plaintiff Leslie Daniels was a minor and still aired her and displayed her in demeaning ways, knowing she was a minor. Defendant reproduced her pictures without our consent. Out of defendant's own words, they tend to make at least some financial gain from the exploitation of a minor without our permission, or the image of a minor without our permission. Forget how they made her feel. I'd have been like, without our permission, she's a minor. You need the parents or guardian's permission. We have no contract with Corey Holcomb allowing him to use the picture and the likenesses of our child who was still a minor at the time. You see how the way I'm wording it gets more to the satisfying the legal elements instead of just like they did me so wrong, they did her so wrong. In court, defendant's new conduct was knowing and intentional. 64. The defendant's conduct was knowing and intentional. The defendants knowingly and intentionally published, produced, portrayed the image of a minor daughter, the plaintiff, knowing that there was never any agreement for him to do so, thus violating Civil Code Section 3344. See how I worded hammers at home? I know how to bring it home. I know how to words to bring it home. At the time that defendant Corey Holcomb displayed the photograph during his podcast, he stated that it was a photograph of Daniels' daughter. There's a lot of pieces out here that I would take, but the lawyer just didn't. I guarantee you, if I put because I'm pretty sure the lawyer knows how to argue. I mean, the elements are clear. I guarantee you, Corey Holcomb would have been in that back room, their lawyer and your lawyer settling, and I'm pretty sure there'd have been a non-disclosure agreement. Don't have it all because y'all don't want nobody to make content off it. A non-disclosure agreement, settle for an undisclosed amount or whatever agreements y'all reach. If I'm telling you, as a result, plaintiff is entitled to recover compensatory damages. Plaintiff's prayer for relief, compensatory damages in amount to be proven at trial, exemplary and punitive damage for the first, third, fourth, fifth, and sixth causes of action, for attorney's fees with respect to the seventh cause of action. 1 second. All right, cool. That's a bet. All right, bye. Everybody's not just single, sitting in a little corner of their house, just hating women all day. I don't know where you get that from. The New Culture Empire, Supreme League team, we don't hate women. I work with women. I know women who are in powerful positions more than men. I don't even get that manosphere. I don't get, maybe the old school manosphere, maybe I get, but this new age manosphere is full of garbage. You know the problem? These ain't got no game. They ain't got no game. See, money don't compensate for lack of drip, lack of whore, lack of stand-up, lack of substance conversations. You can't throw money at that. Either you got it or you don't. Whoa. I did not know that was there. I'm not going to go over the exhibits. Nah, because I didn't know because his daughter popped out. I'm not going to go over the exhibits. I'm pretty sure y'all seen it already. I'm not going to go over those exhibits out of respect for, because I didn't get Anton's permission to. Now, I can review the lawsuit because it's public records, but I mean, the exhibit is part of public records, but I just don't feel comfortable doing it. Now, this right here, see, I typed this up earlier. This part right here is what the lawsuit actually claims. From the complaint, minor, daughter called ugly, a slur about sexual orientations, family depicted as monkey on a t-shirt and sold publicly, image of minor used without consent for profit, claims filed, defamation per se, false light, defamation, t-shirt images, IIED, that's the emotional distress statute, intentional to inflict emotional distress, misappropriation of likeness, minor. The legal breakdown, defamation per se, I said it's strong but tricky, very tricky, Rita. In California, defamation per se equals statement so harmful you don't need to prove damages. The classic categories are crime, professional harm, sexual misconduct, loathsome characteristics. Calling someone a slur about sexuality can qualify. See, so the Daniels, this fits under the kind of the sexual misconduct thing. Now, the Daniels, relevant authority, Smaller are smaller. 2022. Ethical complexities in defamation and false light claims. Georgetown Jail and public policy. Rita and Anton, your lawyer, y'all should get this right here. Another one, Lewis, JB, and Morosi, GV, 2002. Actions, DePaul Law Review. See, these are all the things, Anton, if I was working on your case, I would be researching the class of the examples, how the course usually rules on these, what the elements you got to prove, how they say it, how they do this, the wording, the time, the font, the style, the this. I do the law review, opinions from professionals. See, I call these the professional opinions, because one thing about me, I always look to the professionals for the opinion. So let me take one of these classic examples from the defamation case. Let me read the cases, read the elements, read their cause of actions, and I'm gonna look at Rita's and Leslie's case and be like, okay, these elements fit here. So I'm gonna cite this case to match with these elements. I'm gonna cite that case to match with these elements. And I'm gonna cite this case to support my legal cause of action in real life. These works explains that false statements about sexuality can fall into defamation per se if presented as fact, not legal conclusions. The problem from research in my litigation model, here's the problem. Courts often says insults equals opinion, not fact. So what that means is, Anton, did Corey really know that your daughter's Rita? So given the fact that she's not, it can be like he just talking. So Corey's defense will most likely be, that's just trash talk, comedy, no harm, no foul. False light, very important in strategic claim. This might be stronger than defamation. Pay attention, Rita, Anton. The law, false light equals portraying someone misleadingly in a way that is highly offensive, made with reckless disregard for truth. Now, there's no dispute that portraying Rita and his daughter, I don't know if I didn't see the shirt. I think I seen a glimpse of it. Well, whatever, depicting them as a monkey, that clearly can qualify right here. Why does it matter here? Publicly labeled something she's not, and it was broadcast to a large audience. Case supports, SK Fields, Game Faces, Sports Celebrity, and the Laws of Reputation. P. Siegel, 2014, Cases and Communication Law. These confirm that false identity portrayal, sexual, moral, etc. are actionable, even if not classic defamation. Racial depiction, the t-shirt claim, the strongest emotional hook for a jury, but is legally complex. The lawsuit argues depicting black individuals as monkey equals historically racist and dehumanizing. Academic and legal support for Rita's argument. R. Delgado, 1982, Words That Wound, a tort action for racial insult. Harvard Criminal Law Review. Pilgrim, D. Pilgrim, 2017, Watermelons, Nooses, and Straight Razors. These sources will help Rita explain calling black people monkeys is a recognized racial slur with deep historical harm. I think one of the nuances to that is, if that was a white person saying it, probably hit harder. Since another black person saying it, it may still have the same effect, but yeah, I know it'll hit way harder if a white person is. Courts often rule racial insults alone don't mean defamation. Why? Because they're usually treated as opinion and protected speech. First Amendment, which will be Corey's main point. Corey's lawyer is going to wear that First Amendment out. And since it's a constitutionally protected speech, I mean, if you can't even go to prison by burning the American flag, it's distasteful to our country, but you don't go to prison by burning the American flag. So that First Amendment, that's going, Anton Daniels and Rita Daniels, Corey Holcomb is going to wear the shit out of that First Amendment. Intentional infliction of emotional distress, IIED. This is where plaintiffs often win when defamation fails. Standard. Conduct must be extreme and outrageous. Intentional or reckless, causes severe emotional distress. Rita and Anton Daniels, the emotional distress one, you have to be able to satisfy that high bar. Hell, Go see a doctor for it. Go see a therapist. Play, Anton, you got the money? Play the video for the therapist. Rita, yo, I'm public. I do this all the time. Couldn't leave my house for 3 weeks. I suffer from panic attacks. And get that documented on paper. Now you got the receipt for court. I swear to God, Anton Daniels, I know what the fuck I'm talking about.
You're rocking with the best.
Strong facts Rita has. You have a minor targeted. You have repeated broadcasts. You got monetization, t-shirt sales, and you got the racial imagery on the shirt. That combination helps a lot. Supporting scholarship literature. C.B. Johnson, 1999, Stopping Hate Without Stifling Speech. M.R. Bartels, 2020, Program Defamation. These note courts are more willing to allow IIED when speech becomes targeted harassment and exploitation. And you got that with the minor being targeted. You got the repeated broadcasts of it. You got the monetization, the t-shirt sales, and you got them looking as monkey on the shirt. You can check those boxes off. Appropriation likeness. Very strong claim for Rita. This is low-key the sleeper claim. Civil law, Civil Code 3344. You cannot use someone's name, image, likeness for commercial purposes without consent. Facts. Minor's image shown publicly used to boost, show, and sell merch. And they didn't even get your permission to do it because she was a minor at the time. If Walmart wanted to have her picture on it, they ever have to get y'all consent. That's the easiest to prove. And this shows how Corey Holcomb, like, you didn't know that? You ain't think that far down the road? Why would you put a minors on a shirt? Like, how stupid can you be? That was a dumb move. And then you was holding it up like, and shout out to, what's that lady's name that be on the show with them? I forgot. But she didn't want to hold the shirt up and you got mad at her. She wasn't going to hold that shirt up with that minor on it. You know, why would you even ask her to do that? These talking about, I don't do it, the next bitch will. We call that sucker. Why you want another woman to hold up? Think about psychologically with the girl that be on 5150. Think about her. What if she's a mom? What if she's an aunt? What if she's a grandmother? I don't know how old she is. She don't look that old. What if she has a daughter? Do you think she will feel comfortable participating and holding up a shirt with a minor child depicted as a monkey? Like, Corey, why would you even put her in that situation? You really thought she was going to be comfortable with that? That's why she didn't do it. You ain't got no morals, principles, and values that you stand on in your heart. You are subject to be bought at any time. And a lot of people, they waiting to be bought. They can't wait for someone to offer them something so they can get out their immediate situation, so they can be bought, all to just regret it later for the bag. I'm telling you, it's not what it's caked up to be. Yeah, it provides you comfort. It provides you stability. It provides you security. It doesn't solve all the rest of your problems. Money doesn't stop cancer. Money doesn't stop a blood disease. Money doesn't stop heart failure, liver failure, lung cancer, prostate cancer. Money doesn't stop it. The Daniels. Dover's Garland Productions, Gangland Productions. Reality show falsely portrayed persons as criminal. Plaintiff won on false light. Remember Gangland? Similar. False portrayal harming reputation. Have your lawyer read that case. Doe vs. Gangland Productions. Eastwood vs. Superior Court. Actors' likeness was used misleadingly. Court allowed claim. Supports likeness misuse. Span vs. Messner. False portrayal in published work. Plaintiff won. False narrative equals liability. Miller vs. NBC, 1986. Emotional distress from broadcast exposure. Zacchini vs. Scripps Howard, 1977. Unauthorized commercial use of performance. Strong analogy to monetization. Douglas vs. Hustler Magazine. Unauthorized use of images equals liability. Briscoe vs. Reader's Digest. Exposure plus harm, privacy violation. Cantrell vs. Ford City Publishing. False portrayal, Supreme Court allowed recovery.
Huh? Anton? You better pay attention. I know what the hell I'm talking about. I know what the hell I'm talking about. Roadblocks. This is where Corey's defense will come with. It's comedy, hyperbole. Courts protect comedy, insults, exaggeration. That's going to be his biggest defense. Opinion versus fact. Calling someone ugly is not defamation. Insults are usually protected. Context. Public beef. Because this came after a public argument, defense will argue. This is mutual online conflict. Entertainment. Rita's attorney must beat Corey's attorney to the punch by addressing this before he does. Public figure argument. It's another thing for the Daniels to look at. If Anton Daniels is considered a public figure, if he's cast in that light, the family may be dragged into limited public figure status. So Corey's attorneys may say, well, they're public figures too. That raises the standard to actual malice. Very hard to prove. First Amendment. Courts are very protective of speech, comedy, even offensive racial context. Supreme Elite Team litigation model breakdown. Who has the edge in this case? Strongest claims. Daniels. Misuse of likeness, minor. IIED. Intentional infliction of emotional distress because of repeated targeting, race, and minor. That is your strongest claims right here. By putting that girl on a goddamn t-shirt and making money off it. That's your strongest claim, in my opinion. Medium strip, the false light. The weakest, defamations, because insults are not facts. This lawsuit isn't just about jokes. It's about where the comedy turned into targeted exploitation. The strongest part of the case isn't even the insults. It's the fact that a minor's image was used for profit and that the harassment was repeated and monetized. That's where the case could really hurt Corey legally, right there. All the defamation and anything. As a matter of fact, if you did have section 3344 in it, it looks like this case wouldn't have sustained a demurrer.
My mother, who's 70-something, look better than your daughter. I don't even know how I would be able to accept that. Anton, your daughter ugly as hell.
Because she said ugly over 58 times in this damn live stream.
You got to be so twisted. You should be worried about your ugly daughter. Your daughter is ugly. Your ugly daughter is ugly.
If I said that, if Kevin would have said that, if any black man would have said what she just said, what do you think would what do you think the reaction would be?
So nigga.
Heat got sauce in my hand. She rolling the dice, got looking advanced. Smoking that leaf, coin global stand. On my wrist like a 6, they can't clench. You look like you wanna let go of stress. What's up? I got so okay.